Hello, this is an estate and gift tax online module. We're talking about the gross estate, and particularly section 2033, and I'm Professor Donna Byrne. Now, just to review, we know that a gift is a gratuitous transfer that takes place during the donor's lifetime, and transfers that take place at death are subject to the estate tax. Keep in mind that death doesn't make a gift complete. If the gift wasn't complete before death, then it's not a gift, and whatever it was will be in the estate. So remember that the relation back doctrine did not apply when the donor died before the check cleared. In this presentation, we'll start to define the gross estate. In particular, we'll look at section 2033, which covers property owned by the decedent, and we'll look at a case and a technical advice memorandum. So our only real issue is, did the decedent own this? Okay, here's the starting point. Section 2031 is really like the cover on a book. It says, here's the gross estate, but it doesn't have much actual content. Here's the text of 2031. The value of the gross estate of the decedent shall be determined by including, to the extent provided for in this part, the value at the time of his death of all property, real or personal, tangible or intangible, wherever situated. Now notice that we're including the value of property and not technically the property itself. We'll often say that property is included, but really what we're talking about is the value of the property. We're just adding up a bunch of numbers. And, okay, so the real guts of the gross estate come in all of the code sections after 2031, and we start with 2033, property in which the decedent had an interest. The value of the gross estate shall include the value of all property to the extent of the interest therein of the decedent at the time of his death. So again, we're focusing on the value of the gross estate, the value of the property. Notice the code uses gendered language. It's old and it's not accurate because some decedents are women. You should not use gendered language just because the code does, but if we're quoting the code, we're going to quote the code. Okay, now notice also that this focuses on the interest in property. And that could be many different things. It could be fee title, right, or outright ownership with all the sticks in the bundle. But it could just be a term of years. So, for example, a patent or a copyright only goes for a certain number of years, and then it ends. And maybe that's what the decedent owned. Or it could be that the decedent had a right to income for 10 years, and then someone else had a remainder. So we could just be including a term of years. We're focusing on what interest the decedent owned. Could be a remainder, could be a tenancy in common. Okay, so this is basically the same as the probate estate. And other sections will add other things. We had an early case that said, we're going to read this narrowly. It only means the probate estate. Okay, let's take a look at Estate of Fortunato versus Commissioner. I tried to find pictures of Bobby Fortunato, but I could not. I did, however, look up the whole case, and there's some interesting language at the beginning that you don't have. So here it is. Some of the events upon which this case turned occurred 25 years ago. In many instances, witnesses describing these events gave differing accounts as to what transpired, and the trial lasted nearly 3 weeks. The record is voluminous, 3,560 pages of testimony and more than 400 exhibits. After sifting through the record and after carefully observing each of the 25 witnesses to determine his or her credibility, we make the following findings of fact. You kind of feel sorry for them, don't you? TCM means tax court memorandum. TCM cases usually are fact-intensive, and once the facts are clear, the application of the law is not very controversial. That's what this is. Now, Bobby Fortunato, we're told, had no money. He was hiding from creditors. He was sleeping on a couch at his parents'. He did not have a bank account, because why would he? Creditors would just garnish it. He also didn't put his name on any documents. There's no point in owning anything because it will just be levied for his debts. And so he was seriously avoiding creditors. But he was good at running a business, and so he stayed on with the family business, St. George Containers. I think they've changed names a few times. But they were in New Jersey. Bobby thought they ought to move into California. And so he started the California branch, which actually was quite successful. Now his brother Anthony was officially the president, but really Bobby ran things. And the company paid him well. They listed the payments as officer salary, professional fees, or notes payable shareholders. Basically, they didn't know what to call it. Why? The CFO, the chief financial officer, thought Bobby was the owner. But he didn't have any documentation. This was the head guy, and he paid him. Okay, so Bobby died. I don't know how. Well, our question is the value of the California company includable in Bobby's gross estate? And this turns on whether or not Bobby was the owner. Did he have an ownership interest? Was he a shareholder? Because this was incorporated. If he did, then the estate's taxed on the value of the company. If he did not, then the estate only includes whatever money he may have had in his possession. So we're talking about an ownership interest versus the earnings he may have had in his pocket. So this could easily fit in the property course, right? We're just talking about what is property, how do we know if you own something. The court focuses on a number of facts, and keep in mind this is fact intensive, and there were what did they say, 400 exhibits? Court says there's no objective evidence to show that Bobby was a shareholder. He never wanted to be a shareholder. He was hiding from creditors, so he was avoiding owning things, and so that was one reason. The other was he had kind of a colorful past, and he thought that his reputation would be bad for the company. Right? And he didn't need to be an owner, and that meant since he wasn't, he didn't bear any of the burdens of equity ownership. He didn't bear any risk of loss, and this was fine. He was able to use company funds for anything he wanted. He didn't have anybody to provide for. His only family really was his brother at this point, and the brother already owned everything. So this was the situation. He did have strong managerial skills, and so it made sense that they kept him in charge and let him run things. But what he was paid, the court says, is compensation for his services, and not dividends. Now, this is really backwards from a lot of income tax cases. In income tax cases, we often try to disguise, or we're trying to decide whether a taxpayer was disguising dividends as compensation, because the corporation deducts compensation. But here, we're trying to decide whether Bobby has an ownership interest, and the court says, no, he really didn't. He didn't have any of the risk. He didn't have any title. So we don't include the value in the gross estate. Now, if we had, that may or may not have meant tax. Right? So probably it would have, or we wouldn't be litigating this. But our question right now is only what is included in the gross estate. Okay, let's turn our attention to that tech advice memorandum. Now, this is an internal IRS document providing guidance from the Chief Counsel Office to people in the field, auditing agents or examiners. And this is an explanation from the IRS website. Technical advice memoranda represent the views of the Office of Chief Counsel as to application of tax law, tax treaties, regulations, revenue rulings, or other published precedents to the facts of specific cases. And they're issued primarily as a means of assisting service personnel in closing cases and establishing and maintaining uniformity in the treatment of issues. We want that in the agency, right? You shouldn't get a different result depending on where you're audited or who your auditor is. So this isn't really guidance for the taxpayers. This is guidance for the IRS people, but we can search these, and they tell us how the IRS is dealing with different issues. Okay, so in this case, we're talking about stolen art. Now, do you remember Cesarini from income tax? That was the one where the people found old currency in an old piano, and the question was it income, right? So, and it turned on whether under state law the finder of treasure trove was considered the owner. Okay, well here, this time the question is whether someone who steals property becomes the owner, and it's the estate tax that we're concerned with rather than the income tax. So the decedent, of course, had stolen some art objects while serving in the armed forces in France and Germany. And our question is, okay, should that be included in the gross estate? And it really comes down to, did the decedent own the stolen art for purposes of the estate tax? If the court looks at various kinds of facts about ownership, did the decedent have exclusive possession, enjoyment, and actual command? Well, yes, actually he did, and his family knew it. He was able to sell in discrete markets for profit, and you know, they point out that, wow, he had this orchid collection. How would he have afforded an orchid collection? Well, this is how. And he was able to transfer the use and economic benefits to his siblings. So other people were able to receive this property from him. And the court says, for purposes of the estate tax, legal title is not as important as economic benefits. Okay? Contrast this with Crummy. Remember Crummy with those withdrawal rights that made contributions to the trust into present interests because they gave the beneficiary an immediate right to use, possession, or control or income. There was no issue about whether those kids had an interest, right? We only got to that annual exclusion issue because we had a completed gift. Here, however, the question is whether there is an interest. So the focus is a little bit different, right? In Crummy, the question was what are the legal rights inherent in that interest? Here, it's whether there's an interest at all. And the court says yes, that the thing is being able to control the property and use it, and we will see that theme magnified through the other code sections. So I thought I'd throw in some stolen art that's never been found. And I don't remember the details of these. You can Google it. This one, The Just Judges, is described in Camus' book, The Fall, or La Chute. And here's a Van Gogh that did actually disappear right after World War II and still has not been found. So thank you for watching.